Okay, good morning. I am Judge Abbott. I am here to conduct this bond hearing. This is a hearing to set bond. It's not a hearing to try your case. And Mr. Garrett, you're the only person here in this bond hearing, so I do have information that I need to go over with you. So if you'll listen as we go through this, and then we'll do the bond hearing, okay? As I said, I'm not here to try your case. That's a different court, a different judge, a different day. Today is just about bond. But remember that under the United States legal system, you are innocent until proven guilty. So do not say anything about the facts of your case. Don't discuss the facts of your case with anyone except your attorney. Because anything you say to me, anything you say to law enforcement, anything you say to any fellow defendants can be used against you, okay? Now, during this bond hearing, you're going to be treated with dignity and respect. In return, the court expects you to treat everyone else the same. Anything less than that could subject you to a contempt of court finding, and that could mean an automatic 30-day jail term and or a $500 fine. So please keep that in mind as we proceed. You're here because criminal charges have been filed against you. And because of those charges, you're afforded certain rights under both the United States Constitution and the South Carolina Constitution. Among those rights are the right to a trial by jury and the right to an attorney. However, that does not mean that an attorney will be appointed for you, only that you have the right to have an attorney. Now, court appearances. You have a general sessions court level charge, which means you do not have a trial date set, but you have an initial appearance date. And this initial appearance date is mandatory, takes place at the County Courthouse, 180 Magnolia Street. The purpose of the initial appearance is to determine if you have an attorney on record. Now, failure to attend any court appearance or hearing will result in you being arrested on a bench warrant. You'll be brought back here to jail to sit and wait on the judge to call for you. In General Sessions Court, that may be weeks sitting here in jail. So please do not miss any of your court date. Now, I highly recommend that you obtain an attorney before your initial appearance or any court date. Remember, you're facing jail time and or fines, and an attorney may be aware of certain factual or legal defenses to your charges that you may not be aware of. Also, an attorney may be aware of legal issues related to the conduct of your trial and or any guilty plea that may be preserved for an appeal. Appearing in criminal court without an attorney is a dangerous proposition. Preliminary hearing. Okay, you have a general sessions charge, which means you're entitled to a preliminary hearing. This hearing is not mandatory, and you must request this hearing within 10 days of today's date. This is a hearing to determine whether there's probable cause for your case to continue. At this hearing, you do not testify, present evidence, or call witnesses. However, you and your attorney can question the witnesses for the state. You can find out what evidence they have against you and what they're going to be saying. If the judge at the preliminary hearing determines that probable cause does not exist, your case may be dropped at that point. Now, expungement. Charges in any court that are no pros, dismissed, or anything other than you pleading guilty or being found guilty may be expunged. Expungement means the records of the arrest are removed. In General Sessions Court, you must file a petition with the clerk of court and pay a fee for an expungement. Now, today's bond hearing will be to determine whether you receive a bond, and if you do, whether your bond will be a surety bond, which requires a deposit, or a personal recognizance bond, which does not require a deposit. I will also be determining the amount of the bond and whether there will be additional conditions added to the bond. In determining bond, I am required to consider two questions. First, are you a flight risk? In other words, are you at risk for not attending your court dates? And second, are you an unreasonable danger to the community and or any individual? Now, there are a number of factors that I may consider regarding these two questions, and I will be asking you questions concerning these factors. However, I will not be asking you about the facts of your case. If you are released on bond, you're being released on the condition of good conduct. If you're brought back to jail for any additional charge, your bond may be revoked. You may be given a higher bond with additional conditions, or you may be denied bond altogether. Also, while out on bond, you're not allowed to leave the state without permission of the court. And when I call you up, one of the first questions I'm going to ask you is, what do you plan to do about an attorney? And you can give me one of three answers. You can tell me you're undecided. You can tell me you plan to get a private attorney, or you can tell me you wish to request a public defender. If you wish to request a public defender, you must first be declared indigent, which generally means that you cannot make or cannot bring home more than $240 per week, own any real estate or a business. Now, I do not appoint public defenders. I can only assist you with paperwork and instructions regarding how to obtain a public defender. Now, I've gone over a lot of information in a short time, but I've got 5 important points I want to emphasize. Number 1, you have a right to an attorney. And number 2, you have a right to a jury trial. Number 3, you must appear at all your court dates. Number 4, any inappropriate behavior will subject you to a contempt of court finding. And 5, you should seriously consider obtaining an attorney to assist you in this matter. So when I call you up, please stand in front of the bench here. And at that point, I will answer any questions you have about your rights, or about bond, about this bond hearing. Okay, Kerion Garrett. If you will step right up, please. Okay, Mr. Garrett, you are here on 5 charges. The first charge is murder, and that can carry from a 30-year prison term to life. Okay? The second charge is possession of a weapon doing a violent crime, and that can carry up to a 5-year prison term. And then you have 3 attempted murder charges, and each of those could carry up to a 30-year prison term. So do you understand the 5 charges that you have against you and the maximum penalties you may be facing? Okay? What do you plan to do about an attorney?
Get an attorney.
A private, or you want to request a public defender? Okay, you're going to hire a private attorney. Okay. All right. Now, were you given this document prior to coming into court? Were you able to read over it? Do you have any questions for me about that document? If not, I'm going to ask you to sign my copy and pass it over to the officer, and you hang on to yours. Okay? Now, you're in General Sessions Court, which means that you don't have a trial date set yet, but you have an initial appearance. And that initial appearance is March the 5th at 9 o'clock. Okay? Now, I'm going to ask you to sign this in front of me, but this copy is yours to take with you. Okay? If you'll put those 2 together. Now, how would you like to be reminded of that court date? We can call you, text you, or email you, just as a courtesy reminder.
Email.
Okay? All right. I'm going to let you, for the sake of accuracy, if you will write your email right there, sign your name, and print your name. Okay, you want to change that to a phone call?
Yeah.
Okay, well, let me have this back then, and I'll give it to you in just a minute. Let's do a phone call. What number?
864.
864
431.
431 7 3 8 3. Okay, now if you'll just sign it right there and then print your name underneath. Okay, if you'll pass that over to the officer, please. Now, you have a right to a preliminary hearing. Do you remember me going over what a preliminary hearing is? Okay. And now you can request a preliminary hearing by signing this document right now, or you can take it with you and discuss it with your attorney. Which one would you like to do?
I'll take it.
Okay. All right. Remember, you only have 10 days from today's date to request that. After the 10 days, you lose that right to that hearing. Okay? All right. Let's go over this checklist. And when you don't have any questions for me, I need you to initial where I have highlighted there. If you have questions for me, ask me as we go through. Okay? Number 2 states that what happens if you don't appear in court. You're arrested on a bench warrant, you're brought back down here to sit in jail, wait on a judge. Also, your trial may continue even in your absence, and you could be found guilty even if you don't show up. And then lastly, under number 2, that judge has the option of adding from $1,000 to $5,000 or 1 year to 5 years in jail just for missing your court date. So that's number 2. Number 3 states that I informed you of your right to a preliminary hearing, and I actually gave you a document right here regarding preliminary hearing. 4 states that I informed you of your right to a trial by jury. You can request a jury trial, not just a judge. Then 5 states that I went over these 5 charges against you and informed you of the maximum penalty that you may be facing on all of those, and I informed you that if you cannot afford an attorney, you may be eligible to have one appointed for you. Okay? So if you understand all that, I ask you to initial those. You've initialed those. Okay, if you will turn that one sheet over for me. Now turn it over. We still got to sign it there. All right, number 6 does not apply to you. Number 7 discusses expungement. And number 8 states it's your responsibility to keep the court informed of your current address and phone number. So if you understand all of that, now I'm going to ask you to sign that document. Okay, if you'll pass that over to the officer. I'm going to give you a copy in just a moment when we finish your bond hearing. Okay. Looking at your NCIC report, the only previous charge I see is back in January of last year, and that's a petty larceny conviction. Is that correct? Okay. And I have you living at 555 Walford Street. Is that correct? How long have you been there?
7 years.
Okay. Is that a rental or a purchase?
Rental. I think it's a purchase.
Okay. Is it your home or okay, somebody else's home? Okay. And you've given me next of kin as your mother at the same address. And I want to make sure this phone number is correct. Is that 764-6023? Okay, that's your mother's. And I have you employed at Upward. How long have you been there?
About a week now.
Okay. And how were you employed previous to that job?
How did I get the job?
No, did you have a job previous to that job? Okay, that's your first job? Okay. All right, I have gone over the charges against you, the maximum penalties. And I'll note for the record that, let me have these back here, I'm sorry, that all victims, or there was an attempt, let's see, I'm trying to get them all together without taking the other. There's been proper attempts at notice of all victims in this case, and we don't, I think we may have some victims outside the courtroom listening in, but we don't have any in court to make a statement there. So, at this time, we'll consider bond. Now, I first must inform you that on the first charge of murder, that by state statute, I am prevented from setting bond on that charge. That must go to a general sessions judge. Okay? Now, on the next four, I am allowed to set bond on it. However, again, whatever I do there, you're still here until you go to a circuit court for a bond hearing on the murder charge. You understand that? Okay. Well, I've read over the incident reports and looked at your record and got information from you. And considering all that, I do find, based on the charges, that you are at risk for attending your hearings, and you are an unreasonable danger to the community and or some individuals. So you will be getting a cash surety bond, okay? And I'm going to go through each one here and designate an amount. Now, on the possession of violent crime, possession of a weapon during a violent crime, which can carry up to a 5-year prison term, I'm going to do a $5,000 bond on it. And I'll explain how bond works, if you'd like for me to, when I finish this. All right, the murder conviction is being sent to General Sessions Court. Now, the attempted murder charges, those can each carry a term up to 30 years. I'm going to set a $20,000 bond on each one of those. Okay? So, it's going to be a total of $65,000 bond on the 4 charges excluding the murder. General Sessions bond, $65,000. Cash surety. All right, I'm also going to institute a no contact provision with any of the victims or any of the victim's immediate family. Okay, there's no contact with any of those individuals. Sent to General Sessions. Court. And then charges 2 through 5. We've got a total of $65,000 cash surety bond. And no contact. The victims. And or victim's immediate family. Okay. All right. This is your copy here. You don't have to sign that one. That's for you to take with you. It's got the conditions that I've set forth. Do you have any other questions for me at this time?
What if I don't get this in 10 days, it'll be taken away. But what if so if I signed it, I'll be able to get one, right?
Yes, sir. If you sign it, you're requesting a preliminary hearing. And you can go ahead and sign it tonight. That means that you're definitely going to get one. And then you can still, of course, discuss that with your attorney. You need to advise him or her, immediately that you've already requested the preliminary hearing.
How do I get an attorney?
Well, you're able to use the phone out here once you leave out of the bond court to contact an attorney or contact a family member to, try to get an attorney for you. However you're going to work that, that'll be up to you. But we have a phone out here that you can use to facilitate that. Okay? All right, any other questions for me? All right, then if you'll take your paperwork, you can go back out into the sitting area. The law enforcement personnel will assist you in the process from here on out. Again, you're here until you're transferred to a circuit court to set bond on that murder charge. Okay? All right, then you're dismissed. You can go out sitting area. Thank you.